Yeah, I'll let them in 10 at a time, and then we'll bring them.
You can tell them where to sit there.
Yes.
Yeah, there were things they could have picked out.
Make sure you go into the center to fill in for me, please.
I'll be with you when they throw you out.
All right. I'll remember that.
agree. Good afternoon, everybody. I'm going to call to order the Assembly Budget Committee and the Senate Budget Subcommittee number 3 on Health and Human Services, and welcome everybody here today. We're going to do a little bit of reordering of the agenda because I just wanted to do that, and we're going to call first on the counties to come up and sort of set the stage as far as what's occurring in the local level, and then we're going to go to the department and the LAO. But before we do that, I'm going to make an opening statement because I'm very, very concerned about what is happening here and the reasons for this oversight hearing. We're here to discuss IHSS changes that were enacted in the recent budget package. I'm the author of the bill that requires most of those changes, so I have some real specific and special concerns about these particular policy changes and how they're being implemented, which were originally intended to improve the program's integrity. This is really important to our state. IHSS provides essential services to over 460,000 very vulnerable Californians, elderly and disabled individuals who cannot live alone without care in their own homes. In his budget, the governor originally proposed eliminating 90% of the IHSS caseload through a variety of cuts and reductions. We, the legislature, said no to that proposal. It was one of our caucus's top priorities, and in lieu of making those cuts, the legislature agreed to many tough policy changes, many of which were contained in the 2 bills that really bring us here today. And at the time, it never occurred to me that we would have to be worried about the implementation of these proposals. And the reason is a real credit to the Department of Social Services, because traditionally, this department, which has had to deal with a number of politically polarizing issues and dealing with a number of significant changes in their programs, DSS has been known for its even-handed style and collaborative approach to solving these problems hand in hand with the counties. This, however, is very, very different. The effort to implement AB X44 and AB X419 almost seemed to me to be designed to create maximum disruption, chaos, and fear. And this is very, very different than the experience we've had in the past, and it's disturbing. This hearing today is to determine why this is happening and how we can best address the problems that have been created. As a legislator, one of my concerns is that the administration is using this chaotic process as a means to cut people off of IHSS and to prevent people from providing IHSS services, thereby indirectly accomplishing the program cuts that the legislature refused to approve. And I won't allow an indirect method of doing something the legislature absolutely said no to. The legislature will not tolerate that. When the 58 counties open for business on Monday morning, 2 business days from now, they will have to begin a new process for enrolling IHSS providers, or the computer systems will not allow the providers to get paid. That is extremely difficult to swallow here, that we're going to cut people off of benefits as of Monday if they can't comply in a system that is set up to not allow them to comply. And I want to believe that this is unintentional and accidental, and that we can resolve this with everybody in the room reaching an agreement as to how we can implement this in a reasonable, sane, and humane manner. Counties don't know what the process is going to be. They don't have the necessary materials to conduct the new enrollment process. They don't have the contracts or the resources to conduct the background checks. Guidance that's being provided by DSSS is in conflict with itself internally and often in conflict with current law. And in fact, I've been provided with a letter from DSS that says they can't comment today on one of the major provisions of the bill regarding background checks because of existing litigation. As an attorney, I understand that, but somehow the counties are supposed to implement the policy by the end of the week. Counties don't have the staff or the facilities to conduct the required orientations and the face-to-face interviews. They don't even have, in many cases, the necessary authorization by the Department of Justice to conduct fingerprinting. So it seems pretty clear that all 58 counties will be out of compliance on Monday morning, and that providers will not be paid, and that recipients will not get the services they are entitled to. Consumers and providers are afraid and they're confused, in part because of a letter that was sent out the week of October 5th. I've heard reports of thousands of people every day coming down to county offices, fearful that they're going to lose their care if they don't immediately comply. Basically, the letter has overwhelmed the county's infrastructure and ability to respond. Yet, this probably would have been avoided had there been a stakeholder process in place and had we dealt with this in a manner that we've dealt with similar kinds of issues in the past. And fear is a very common theme here, and this is something that is very worrisome to me. The tone of the letters, there's heavy anti-fraud rhetoric in the CD that went out. It plays more like an America's Most Wanted episode than a warm welcome to the IHSS program. And so this hearing is posing the question, are we trying to root out fraud from bad actors, or are we trying to intimidate providers from providing services and recipients from receiving services? And as I've said before, why does this effort differ so dramatically from DSS's past history of success? Is it an accident? Is it because DSS is weakened by furloughs and staff turnover? Is it intentional? As I said, a backdoor mechanism to do what the legislature said we would not allow. And I'm hoping for an answer before we leave today, as well as a solution to the mess. Over 800,000 consumers and providers will be impacted, and we owe it to them and all Californians to get it right and to do it right. And before we go any further, I want to take one more moment to comment on one reason why I think these particular bills may have caused such chaos, and that's the process from which they came. 2 days ago, Speaker Bass suggested that the Big Five process was being overused in determining policy. And this hearing today illustrates one reason why I believe she was absolutely correct. The agreement for the IHSS changes that we're here talking about today were contained in bills that were negotiated in the Big Five process. They were the result of a deal that was reached in a back room by a small group of people that had very little knowledge of how the IHSS program really works. And I would also add that they probably had very little knowledge of the history of IHSS and why we have such a program. We have this program because decades ago, California as a state decided we were no longer going to institutionalize our disabled and our elderly citizens in state hospitals and nursing homes. We decided to enable them to remain in their homes. It's both more humane and less expensive. IHSS was developed as a program to keep people out of institutions and in their homes. Ironically, the method by which these bills are being implemented will result in IHSS services being denied, and these same folks will end up institutionalized. Thus, we come full circle. And in the meantime, we cause enormous amounts of human suffering. So in this room today, we have literally hundreds of experts on IHSS, hundreds of years' experience collectively, but there's only a handful of people that probably saw the bill before it was actually enrolled. And so it shouldn't be surprising that now on the back end, we've got to do the effort that we should have done on the front end. It's going to need some changes to make sure that it works, and yet no one seems empowered to make these changes. So I'm hoping that these changes will be agreed upon here today and that we can all leave the room on the same page and knowing what we're going to do from here. But it also provides the best example of why we need to craft policy in an open, transparent process with stakeholders having influence in the process and people with expertise having influence on the process. So I think it's pretty clear now what I intend to achieve in the hearing. I know there's a lot of different members here that have a lot of questions. I'm going to make time for lots of questions as we go along, but I would like to call on Senator Leno if he has any comments as the chair of the Senate Budget Subcommittee.
Thank you, Madam Chair, not only for the opportunity to just say a few words of greetings to everyone who've taken time out of your busy day to join us, to give us your life experience with the real challenges to the program as we see them right now, but also for calling the hearing itself. I think every member is hearing from their counties as to the inundation of calls and visits, serious concerns of both providers and consumers as to what their future status is going to be. And as we get into all the details, and Madam Chair, you've laid out all of the components of the hearing very clearly. I just want us to not lose sight as we get into the nuts and bolts of the legislation and the implementation of it, the potential abuses of discretion that we are concerned about with regard to the implementation, but that we're talking about very vulnerable human lives, the most vulnerable human lives in California. And there are people shaking in their boots, losing sleep at night because of the situation that has been created. So I hope we don't lose sight of that. I'm personally dealing with the health concerns of aged parents. I'm sure many of us in the room are doing the same. But it's a real eye-opener for those who need assistance from the state to be able to stay in their home and to be able to take care of loved ones. This is a very sensitive issue area, and we're talking about hundreds of thousands of Californians. So again, thank you, Madam Chair. This is an extremely important hearing, and I hope that we, by the end of it, do reach some outcomes which can improve upon what is just a huge mess right now.
Thank you, Senator Leno. Just a couple of housekeeping announcements before we start with our first witnesses. There's comment cards available for members of the public so that you can weigh in, because we do not have a public comment period scheduled. And I just finished saying how important it is for the public to weigh in on these kinds of processes. So there are comment cards. You also, I think, have my email address as well as the other email addresses of all the other members. So that's another way to weigh in. We're going to take questions from the members after each of the panel discussions. And we are scheduled to complete this hearing today by 3:30, and I think we'll have adequate time. So as I said, I reordered the agenda slightly. We're going to start out with the county concerns and feedback, Frank Mecca and Diane Kalijian, and then I'm going to allow the Department of Social Services to come up and respond to the counties. But I want to at least start out with basically what's happening out there today in our local communities. And welcome. Go ahead, and after both of you finish, we'll have a chance for questions.
Thank you, Madam Chair, Mr. Chairperson, and honorable Assembly people and senators. My name is Frank Mecca. I'm the Executive Director of the County Welfare Directors Association. We represent the 58 county human service agencies in the state who are responsible for, among other things, administering the IHSS program. We're here today because we think there's a critical issue before us. In 4 calendar days, 2 business days, thousands of vulnerable elders and people with disabilities will be in a position where they will not be receiving critical home care services they need, to which they are entitled and to which we have assessed them as needing in order to stay safely in their own homes. We think this is a health and safety crisis of significant proportions, and we very much thank you for convening this hearing today. We'll start with the end. The county welfare departments in the state unanimously asked the legislature and the administration for at least a 3 to 4 month implementation window after we receive comprehensive and clear instructions and guidelines and materials from the state in order to rationally and efficiently implement programs so that they have the desired impact of increasing program integrity and making sure that people receive the services that they need. We've prepared a handout for today, which I believe all of the members have, which I will be speaking from. It's a lot of material, and I'll probably go quickly, and obviously will be available for questions. Just very briefly as to how the November 1st problem is presenting itself. Statute requires that for a new provider enrollment process, new providers, and to some extent current providers, complete a new enrollment form, receive a criminal background check, and attend or receive orientation material. The state has programmed its computer system so that no provider can be paid until these steps are complete. If you turn to the second page of my handout, the problem is, as a growing number of counties have put in writing to the Director of the Department of Social Services, implementing the provider enrollment steps by November 1st is absolutely impossible. For a lot of reasons that we will detail in our testimony. Since the presentation was prepared for your packets, additional counties have weighed in. It's now 23 counties. I believe Santa Clara, Sonoma, Riverside, Stanislaus, San Francisco, and Madera counties have been added since your packets were put together. And I will go through in my testimony the major reasons that we believe that it is absolutely impossible to implement that requirement in the required time. I think it's important to point out that we're not just talking about new recipients who are coming to the program after November 1st. It is very frequently the case that existing recipients will have a change in provider. A provider may move. A provider may get a different job. A provider may decide not to provide care anymore. Anytime a consumer who's currently a consumer needs a new provider, even if that provider's been providing IHSS for years, that under the state's interpretation is a new provider relationship, and that person would need to be cleared. So this affects new consumers, but it also affects consumers who experience a break in provider. What we've been told, and we've been talking amongst ourselves as to whether or not there's ever been a situation where we've ever been told by the state that because we cannot meet the implementation deadline, what you need to tell the consumers is, we're sorry, but you have to fend for yourself. And that's essentially what we've been told is the state of affairs. We've been told that for IHSS recipients who need a new provider after November 1st, they have two options. They can pay out of their own pocket, or they can ask a provider to work for free. In either case, the state has told us that they may be reimbursed for services rendered if the provider is ultimately approved. We've asked for clarification as to what the conditions would be under which they would or would not, and we've not received that clarification. So essentially, a recipient has no idea as of November 1st, even if they can find a provider who will work for free, whether or not that provider will ultimately be paid for the work that they do. In reality, we're talking about extremely low-income people who are living on most typically SSI, and for providers, we're talking about extremely low-wage workers. So it is not realistic for the majority of recipients, in my members' opinion, that they will be able to find providers who work for free, or that they will be able to somehow find enough money in their resources. So we think they'll go without services, remain institutionalized, or have their conditions deteriorate and their health and safety be jeopardized. The next slide begins sort of our recitation of what would have been the major problems with the implementation process. Before I begin this slide, I think it's important to point out that this process has been unprecedented. Typically, when you adopt policy changes in trailer bills or otherwise, the Department of Social Services engages counties and other stakeholders in meaningful collaborative meetings and efforts to implement changes efficiently and effectively and consistent with legislative intent and as fast as we possibly can. In this case, none of the typical collaboration occurred, and it is not clear to us why. Essentially, stakeholders were provided, usually late on a Thursday or Friday night, drafts of instructions or materials, often with significant problems, given very short time frames to give feedback, maybe 3 to 4 days, probably on average. Stakeholders, despite the unrealistic time frames, in many cases work day and night to provide meaningful input, 90% of which I would argue has been ignored. And I think it's not a surprise to us that the resulting instructions have been so flawed and incomplete. And I can't underscore enough how atypical this process has been of the normal relationship between DSS and the counties. Going through the next page, the first problem that we have is that the instructions are very late and most haven't been finalized. We only have one set of instructions that have been final as of October 27th, and on our handout you can see that at least 5 of the necessary all-county letters, which is the instruction vehicle, have not been provided to us in final. And counties cannot implement state law changes based on non-final all-county letters. Legally, it creates a significant amount of risk, and it also creates a situation where operationally we're implementing in a piecemeal fashion, which overall is much more costly and inefficient than getting it right the first time. On the next page, there have been a number of areas, significant areas, where state guidance to counties and to consumers and providers have been in conflict with state and federal law. The first issue that Madam Chair pointed out was a most unfortunate informing notice that went out on October 5th to recipients and consumers, which we think has created a significant amount of fear and chaos in counties. This informing notice provided much erroneous information to recipients and providers about when they need to complete their provider requirements. It implied that there were requirements that we don't believe the law suggests. It implied that there's personal attendance required for orientations for many people for whom we believe the law does not require such. It mentioned home visits that will occur to consumers with just enough information to scare the wits out of people, but not enough good information for them to fully understand the legislature's intent. As a result, as you may have noticed from the many letters that county welfare departments have sent to the state, our offices have been overwhelmed by phone calls and visits from consumers and providers that are coming in asking us questions to which we don't have answers, trying to file paperwork with required material that hasn't yet been developed. And we're spending a significant amount of our resources just managing the fear and chaos of our offices, which diverts attention from actually implementing the changes that you have put into the trailer bill. The second major issue with respect to what we believe is a violation of the law is the draft all-county letter suggestion that any felony or serious misdemeanor bars a person forever from providing in-home supportive services. Our read of the law is that it's quite plain and quite clear that the Welfare and Institutions Code bars people for 10 years for certain felonies. We think that this is a significant and sort of on its face pretty major departure with current law. The state also requires that counties share criminal background information with the state and with other providers in violation of what we believe is a penal code section that prevents us from sharing that kind of information. It's an issue that we've raised with the Department of Justice. They've acknowledged that it is an issue, and we've not had any effort to resolve that issue. These issues are of significant concern for counties and their workers because of the potential liability it creates for following all county letters that are in violation of our plain reading of the law, and yet our typical way of implementing programs is to follow the guidance of the Department of Social Services. And these are issues that absolutely have to be resolved before we implement this process. The next page starts to identify some instructions where there are major unresolved legal questions, and I won't talk about all of them. For example, it appears that people providing services for children will have to go through a different type of criminal background check than the one identified by the state. That's information that a public authority in the state obtained from the Department of Justice. The department has not confirmed whether new providers who serve IHSS recipients will receive back pay if they're ultimately approved. It's not clear if people who are currently approved and on public authority registries can use parts of that approval as part of the new process. In the interest of time, I think it's important to point out this is a small number of scores of additional questions that have been raised by counties in letters to the state. Counties have been asked to check a suspended and ineligible provider list at the Department of Health Care Services without proper instructions, and you can read the rest on the slide. On number 9, I do want to underscore the fact that you've created an exception from paying for the background check for people with indigency, though the state has not given us any information as to how to apply the indigency fee waiver, and yet there are people in 2 days who will be asked to begin their criminal background check process. The next slide, other implementation barriers that we couldn't sort of neatly characterize up to then in one of the categories we've talked to up to now. You appropriated funds for the counties to conduct many of these processes. The state has not allocated any of those funds to the counties for reasons that we absolutely don't understand. As many of you who are from local government or talk to your local government colleagues, we typically don't bet on the come when it comes to money from the state. It's often not the best way for us to work. But in this case, you appropriated the funds. They're sitting in the administration's coffers. The monies hasn't been allocated to the counties. We can't train our staff on materials that we haven't yet received. The criminal record clearance process requires that counties establish a relationship with the Department of Justice. The Department of Justice won't give us criminal background information until we establish a relationship and have our own staff cleared. 33 counties have such clearance, 24 don't, and have been told it will take 4 to 6 weeks for that process to take place. Obviously, 4 to 6 weeks is a lot longer than the 2 business days that we have left. Significantly affecting our workload locally is a state computer glitch related to the court action around the cuts to IHSS that were adopted as part of the budget. As many of you know, there's been a court action to enjoin the state from implementing certain cuts that were enacted as part of the budget. The state programmed its computer system known as CMIPS to effectuate the cut. When the court enjoined the state from issuing the cut, the state told the court, we can't unprogram the computer. We were able to program it, but we can't unprogram it. Now, counties don't typically have very high expectations for state-run computer systems. But this problem was a surprise even to us. What the state told the court was, counties have to manually go through 130 some odd records in CMIPS and manually undo the cut that the state's vendor was able to program. It's been a huge resource strain. Counties are pulling people off the line to try to unprogram manually the CMIP system so that we can comply with the judge's order, which is that no one have that cut. I think it's important to point out this is a state system, not a county system. And while the state programming problem was created not by us, there's a huge resource strain at this very moment where we're trying desperately to comply with a court order while staring a Sunday deadline for implementing the provider enrollment process. I think it's also important to point out that we've not been given instructions about what happens for those cases where it's inevitable that clients fall through the cracks and the cut actually occurs, and we have to undo it. Final implementation barrier that's really critical, and it's really a category. All instructions and materials that we've received only in English, despite the fact that by law the state has the obligation to translate materials and notices into several threshold languages. The orientation CD that the state developed is only in English. Many of the instructions are difficult to understand and are not in formats necessarily where people with disabilities can access them. Now, it's important to point out that under the law, providers have to sign under penalty of perjury that they understand the rules when they fill out the provider enrollment form. How can we ask people to sign under penalty of perjury that they understand what we've told them when we know we've told it to them in a language that they don't understand? It's a completely untenable situation. Now, what the state has told us is you just need to translate counties. Find whatever non-English speaking staff that you have, pull them from your child welfare program, pull them from your adult protective services program, and it's really a completely untenable situation for us. It's the state's obligation, and it's really a prerequisite for efficient implementation of programs for the state to meet at least the minimum translation requirements that are required under the law. There have been counties that have also objected to the tone of the orientation CD that's been developed by the state. And I think it's interesting that in a letter that Monterey County sent that's in your packet, they pointed out that in a 39-minute presentation, the word fraud was used 41 times, accompanied by 5 film clips of handcuffs being applied and 6 clips of clanking jail doors. In Monterey's opinion, this is not an acceptable message to give to prospective providers who will be intimidated from pursuing work, while prevention, identification, and prosecution of fraud is important and it's a priority to all of us. This climate of fear and chaos is going to discourage people from taking care of HSS recipients, which just results in them being in more expensive institutional care. The next slide, my colleague will talk more about, but once we have clear instructions that are not riddled with inconsistencies or in violation of the law, that have been translated into the required languages, that's just the start of implementation. That's when counties hire staff, we train staff, we obtain space, we develop materials, we advise our clients and consumers. The implementation process, the hard work of implementation is what the counties do once the instructions are clear. And we have no time to do any of that while we're still talking about just getting instructions. And so just to conclude, I know the time has been short and I've spoken quickly. I just want to underscore a few points. This process has been unprecedented from our standpoint, both in terms of the lack of collaboration and the complacent acceptance that the best we can do for the most vulnerable people in our society is to tell them we're sorry, we couldn't hit the date. We've never been asked to do that before, and we don't understand why we're being asked to do so now. The implementation deadline of Sunday, it's Wednesday, is ludicrous. And it's unacceptable to county human service agencies to make consumers, elderly and disabled people, suffer for the failings of the administration. Finally, I think it's really important to underscore something that Philip Browning, who's the director in Los Angeles County, pointed out in a letter. It may appear that rushing to implement every item in the trailer bill will enhance program integrity. But in the opinion of Director Browning and his colleagues, it actually has the opposite effect. To quote him very briefly, he says, "I realize that you're under severe time constraints, but I believe that by rushing the restoration of cases, we are potentially creating errors in the program. This activity, combined with the new provider enrollment procedures, in my estimation, has caused a setback to the fraud prevention and deterrence program in Los Angeles County." When staff are dealing with chaos, answering questions to which we've not been provided answers, trying to ease the fears of clients who've been scared out of their wits by inappropriate notices, they're not doing their job, which includes being on the lookout for program integrity and fraud issues. If we have processes that won't hold up legally, then those few, in our estimation, unscrupulous people involved in the program, we will have a harder time upholding a case against them. So to those who say we have to do this because we have a fraud imperative, we think you're having just the opposite effect. So finally, what are we asking? What we've said earlier, we need at least 3 to 4 months from the time when the instructions are clear and the materials are complete and translated. And we need a process that's truly collaborative, a process that we use on almost every other major implementation of significant public policy. What we have around the corner from the trailer bill is more IHSS program changes, finger imaging of recipients, fingerprinting time cards, training social workers, targeted home visits and targeted mailings. If we continue the process that we're using up to now, then we can expect the same problems over the next 6 months that we've experienced over the last several. So thank you very much for your consideration.
Thank you very much, Mr. Mecca. Diane Kaligian from the Human Services Department of my home base, Sonoma County.
Well, good afternoon. I'm Diane Calgin, and I am the Adult and Aging Services Director for the Sonoma County Human Services Department. In addition to in-home supportive services within the Adult and Aging Division, we also have Adult Protective Services, the Area Agency on Aging, the Multipurpose Senior Services Program, Veteran Services, the Public Guardian, Conservator, and Administrator, and we also have the Public Authority. And we're all co-located in one location in Santa Rosa. In Sonoma County, our IHSS caseload is a little over 5,100 clients. We have almost 4,400 IHSS providers. Every month, we add over 80 clients, new clients, to our caseload. And every month, we add about 190 new providers to that pool of providers. The Sonoma County Human Services Department is not prepared to fully implement all the new IHSS requirements by next Monday. We're asking for additional time to administer the changes to the system in an orderly and reliable manner that has integrity for the county and for the clients and for the providers. I've worked for Sonoma County for 22 years, managing programs that serve older adults and people with disabilities. We've developed a number of new programs. We have implemented federal and state and county initiatives, and we've created new processes for serving clients. We've never been asked to administer extensive program changes involving over 9,000 people and been given less than 30 days in which to do it. And in those 30 days, with incomplete instructions, we are being expected to put systems in place, train our staff, and provide information to the community, all without suspension of our daily work. This is unprecedented. It comes at a time when the county staff are already stretched due to reduced funding and staff resources. The standard for good administration of social service programs has included a dialogue with the state agency to understand the required changes and the steps necessary to make the changes on the local level. The dialogue usually takes several months. The current process has been very rushed. Since early October, a partial set of instructions have been received detailing major program changes that are to be implemented November 1st. Since then, we have received a stream of draft information, but nothing has been finalized. This rushed implementation on November 1st has not allowed for the meaningful dialogue and feedback for successful implementation. Counties still do not have all the information required to make the needed changes in our processes or to develop a local implementation plan. The response from clients and providers has been overwhelming. People began calling the first week in October when they received the letter advising them of the changes in the IHSS program. The letter was intimidating to a vulnerable person who knows that IHSS services allow them to live independently at home. One elderly woman called her social worker immediately when she received the letter. She was anxious about leaving her home in fear that she would miss the unannounced home visit and that would terminate her from IHSS. She was actually afraid to leave her house. We have been inundated with calls to IHSS and with a number of people walking into our office. Clients and providers want to do whatever they can to comply and to continue to receive IHSS. The frustration for our staff is that they are not able to give accurate information that instructs clients and providers on how to comply with the new requirements. This past Monday, a disabled woman came into the office from one of the outlying rural areas, and she had with her her two adult daughters who are her IHSS providers. The daughters wanted to get the background check information so they could get their fingerprints done. They wanted to sign up for orientation, and they wanted to get the forms that they needed to complete. The county staff were not able to give this family the information they requested because the system and the resources have not yet been provided by the state. Though these daughters, who are currently their mother's provider, will continue, and their mother will continue to get services, this family expected the county to have the necessary information for them with 1 week in advance of these changes that were taking place. Our social work staff have been diverted from their regular responsibilities of enrolling new clients and seeing clients for their annual renewal visit. Instead, the social workers have been responding to numerous phone calls from clients concerned about losing their services. Our IHSS payroll staff time has also been diverted to make changes in the state's data system. Due to this chaotic process by the state to reduce IHSS services and the subsequent court injunction, Sonoma County and all the other counties are faced with implementing manual data entry corrections to thousands of client and provider records in the state's data system. In Sonoma County, we have 5 payroll staff that process over 11,000 IHSS provider timesheets every month. It took 3 experienced and adept staff all day to reinstate the programming for about 500 clients. We still have over 1,000 client records to change. The county was not provided by the state with a complete list of clients whose programming was changed. Several hundred names were missing from this lengthy paper list that we were sent, and we discovered that through phone calls from clients and providers. The IHSS program manager had to make a telephone call to obtain the missing pages from the original report that was supplied to the county. If the counties don't get this process completed by Friday, clients will have reduced hours or will be eliminated from the program, and providers may not have timesheets and cannot be paid. At the same time, and since the impending new provider enrollment process is unclear, this week we've instructed our payroll staff to prioritize the enrollment of new providers using our current process so that next week new providers and clients will be able to have a provider to work for them. All these tasks must be accomplished by close of business on Friday because the pay period ends on Saturday. Corresponding to all these changes is that next week is a very busy payroll processing time for our staff. A social worker from a senior apartment building that serves low-income elderly people told me about 2 older women who are both in the same hospital and are preparing to come home this week. One of the women has an existing IHSS provider. The other woman does not. The hospital discharge planner is requiring that a home care provider be in place before this lady can come home. Unless the woman who is being discharged from the hospital today can find a provider, complete the provider enrollment form, and get it to our office before Friday, she will have to go to a skilled nursing facility or she will come home unsafely. The Sonoma County Public Authority Registry has over 500 providers on it. These registry providers have had a criminal background check, and that's a local requirement. They've been through an orientation, they've completed an application, they've been interviewed by registry staff and provided references. Our usual process would be that a provider would be referred to a person in a situation such as this woman who's coming home from the hospital. However, with the changed requirements for provider enrollment, the Public Authority Registry will not be able to operate next week until the registry providers complete the new process. The Public Authority has been conducting orientations for registry providers since 2002. Until now, the usual number of providers is less than 20 people per month who attend orientation. The new orientation process will require a much larger meeting space and more staff to assist with required forms and copying. The new process will require the Public Authority to conduct orientation for close to 200 providers each week. This includes new providers and the existing almost 4,400 providers who must also attend orientation prior to June 30th. This is a daunting task for a staff of 6 people. Translation of materials and the ability to conduct the orientation in Spanish is necessary for the public authority staff to meet the needs of our community. The state has not given us the material in a language other than English. In conclusion, Sonoma County Human Services wants to appropriately comply with the new requirements. We don't have the information we need, the answers to specific questions, or even the finalized forms to use. We want to train our staff and be adequately prepared to answer questions for clients and providers. The first call our receptionist received this last Monday morning was a mentally ill woman who's in frail health, physical health, and she had spent the weekend worrying and ruminating that her provider of the past 10 years couldn't continue to work for her. This client was hysterical, she was anxious, as was her provider, and she required both psychiatric assistance and help from her medical doctor in order to calm her fears. The chaos that has been created by rushing these changes is bad for frightened, vulnerable people, and the lack of clear and complete instructions makes it impossible for counties to meet these new requirements. I thank you very much for your time today.
Thank you very much. And now I want to take some time for member questions. I just want to start with one very brief, hopefully quick question, Ms. Calgian. Did you say you have 6 staff
We have
to do all of this?
6 public authority staff who will be conducting the orientations.
Okay. Other members? Mr. Adams?
Well, thank you very much, Madam Chair. Actually, I wanted to, with your indulgence, just take a few brief moments to share some of my thoughts about the problem as it relates to some of the bigger picture. And I want to attach myself to some of the comments you made earlier about the intrinsic problem with sort of these Big Five negotiations and why this is such a problem. I couldn't agree with you more. This is exactly the type of problems that you encounter when closed-door negotiations occur in the wee hours of the morning and then implementation is expected, almost immediately. There's no conceivable way for the state to have prepared itself adequately to prepare the counties, and obviously the counties are now the poor luck beneficiaries of tremendously bad planning on behalf of the state of California, and for that, I think we owe you a collective apology. I will tell you this. I think that I'd like to take it one step further. It's not just a function of the Big Five not being a sufficiently adequate forum for discussing these issues, but this stems from a larger problem, and that is the state of California carries on in a legislative capacity through the budget year in a common disregard for a 2/3 majority requirement that the state has still, and until it doesn't change, still exists. And when we conduct budget committee hearings all year long in an environment where a simple majority vote can move legislation along towards a final budget resolution without regard to the 2/3 consideration, we have essentially de facto created a phony document that has to be renegotiated either in the final committee, in the drafting committee, or in the Big Five chambers. It is fundamentally a failure on the part of the legislature to legitimately address the budget from day one all the way through the process with regard to the legitimate and real political dynamics that will ultimately determine the final document. So I say shame on you, legislature, again. I think it's a function of our failure to acknowledge that political reality in dealing with the problem that has lent itself to this. As it relates to my particular counties, Los Angeles County and San Bernardino County, it is astronomically difficult for me to go back to my constituents and express to them that this is a perfect system. IHSS is fraught with fraud, and we know that because we have numerous accounts, both from LA County and from San Bernardino County, of problems that exist. And the fundamental failure, again, is on the legislature, not the counties, because we refuse to provide you adequate funding, nor do we provide adequate investigators to go forward and actually investigate these claims and root out that fraud. I will not stand up here or sit, for that matter, and pretend that there's not a real problem. There's not real waste, there's not real abuse, there's not real fraud. There really are. Fresno County is a perfect example because they have an investigation unit and they've actually looked at it. Evan Hopper did an incredible piece in April in the LA Times outlining amazing amounts of evidence of legitimate fraud that exists. So make no mistake, there is fraud in there, but the system is a viable system and one that I actually believe in. I firmly believe in the IHSS system. I think it ultimately, when done effectively, saves the state enormous amounts of money, and it does provide dignity to families who are in desperate need of trying to stay home and close to their families and not have to be institutionalized. And I want to see that system succeed. But in order to do so, the state of California needs to get up and take its responsibilities seriously, address these concerns in a timely fashion that gives the counties the tools that they need to do it. And I think it begins at the very beginning of our budget process and should follow through. I am a strong advocate for the idea that we should be providing the resources and the revenue to make sure that you have the tools that you need to run the departments effectively. And I thank you, Madam Chair.
Thank you, Mr. Adams. Senator Ducheney, and then Mr. Nastandi.
Just a couple of responsive comments to some of them. And Adams and I'm waiting anxiously for the department's response. But I mean, the way this comes down, and we do bear some responsibility because we did pass the silly bills. But there were a lot of us here, Mr. Adams, who didn't think those were the right ways to address the fraud. I think everybody agrees there are issues with that. I think a lot of counties have actually been pretty creative. I know San Diego's worked on it. A lot of people are trying to figure out what are the parameters, so that's what we ought to do. Most of what's going on here is that the counties are being asked to do things that, as they point out, take them away from doing the normal things that would stop it. And some of these provisions would have helped, but one presumes in those discussions with finance that they actually have spoken to the department and they understand the program. That's not always the case. We're learning a lot. But I don't think it was us who picked the date. This was the governor's proposal. It was the department's, one presumes the governor represents the department that he's in charge of administering. And Department of Finance and the governor are supposed to let us know. And I think that those questions were asked. And frankly, in the legislature's budget coming out of conference committee, these proposals were not there. So it wasn't about the 2/3. I don't think anybody really thought some of these things were the way to go. It came out at the end because finance insisted that they couldn't save the money unless they got it this way, and people asked them over and over again, you really think that you can implement this on the schedule you're suggesting? And they said yes, yes, yes. And so now we're finding no is more likely, and I think it is on the state to figure out. I mean, it doesn't make any sense at all that we've said, you know, we change the system the one way and the court tells us to change it back, and then we say, well, you guys go figure that out. I mean, that's silly. And to ask your people to do these things without the tools doesn't make sense. We can't ask providers to meet statutes that you can't implement. And I, you know, the legality, if we had to do something, it seems to me there have been more than one occasion when this department and others have not met certain implementation deadlines of the legislature, but when they're making progress and everybody agrees you're doing what you're supposed to do and you're moving on a path and it's going to take 3 months to do it. I mean, I can't remember the last time I got a report on time from this department that was by statute. So, you know, that happens a lot, that the department misses deadlines, and I think, you know, what's more important is that we have a method by which people are not being penalized for not complying with a law that nobody's sort of figured out what the regulations are yet. So, you know, we'll be interested to hear from all of that, and I think it is a caution for the future, but, you know, we do take the governor's word seriously, maybe erroneously sometimes, but nonetheless seriously.
Thank you, Senator. Assemblymember Nastandi.
Thank you, Madam Chair. The previous two speakers covered a few of the points, but I will say I was warned on the day of the vote by another gentleman that's going to testify on the panel here that this would be a problem, Jovan, and he was right. So I agreed that it's a big problem we have to fix, but my request would be to you folks and maybe other people that are going to be testifying is, we know we're going into another budget problem, and I agree with what Assemblyman Adams said. This program is a good program in many circumstances, but we're out of money. And so please bring with us suggestions of how we can score some savings here, because we simply have no choice. I look forward to hearing some ideas about what we can do going forward to turn back to cost. Thank you.
Thank you, Assemblyman. In response to a couple of comments, I think it's important to point out that we didn't come here to take issue with the policies as they've been enacted. That was sort of an issue for last year. They are the law of the land. I mean, we have every intention, unless they're changed, to implement them as efficiently as we can. So this is not about a referendum on whether we ought to be doing these things. The question is how. And from the standpoint of savings, there were savings, I think, that were scored assuming the rational and efficient implementation of a number of program integrity initiatives. And I think what the director in Los Angeles pointed out in his letter is that this does more harm than good to your savings. So we suggest if you want to maintain the savings that you assume that are going to happen, then we have to actually rationalize this process, because if the process continues as it is, that's what we think will erode your savings.
Assemblymember Swanson.
Yeah, well, I would hope that someone would challenge the policy as bad policy. I think you know, we always talk about the questions of unintended consequences, and this seems to be the mother of unintended consequences. And to the extent that you point out to us the father, mother of unintended consequences, it seems to me that the more you point out to us that that this is not workable, that the timeline is unreasonable, and in fact that the objective is not going to be addressed, and that is saving money, and in fact it will cost us money. And I think that we've had our policy debate, and those of us that voted against this lost, but I think that this is it's not going away because it's bad policy, and I think that we need to have that discussion, and then the question becomes, what are we going to do about it? Are we going to actually take action as a legislature to correct what some of us believe is a mistake, and I believe more accurately is morally objectionable to attempt to balance the budget on the backs of the poor and the helpless. And so I think that we need to address this question as a legislature in a timely manner to assist the counties. And if, as some of us believe, we made a mistake in our public policy decision, then we need to correct it and do that quickly. So I hope that we will receive as much information as possible during the course of this hearing why this is not good public policy, and in fact why any careful analysis of the services that were provided will show that the state was benefiting and saving money in the long run by providing these services. And so I hope that that's the direction we go in, Madam Chair.
Thank you, Mr. Swanson. I think lots of good comments here and lots of good discussion. I did want to just ask Mr. Mecca to respond to at least one of the comments that I heard concerning whether or not concerning this debate about the extent of fraud in the IHSS system. And I know there is a belief out there. I don't share it, but there is a belief that there is widespread fraud. But I know that there have also been studies done by the department itself that has shown something like less than 1% of actual either suspected fraud or proven fraud. So can you enlighten us just briefly on that? Because I know that Senator Ducheney has one last comment, and then I'd like to get to the department.
From our standpoint, we've not seen any good data that would suggest that the incidence of fraud in IHSS is any greater or less than the incidence of fraud in any government program. And that's not to say fraud isn't something that we should care about, because we do. We, in fact, CWDA sponsored a legislative initiative in 2004, the Quality Assurance Initiative, to build on efforts underway to try to improve program integrity in the program. But the claims that, many of which were made during last year's budget debate, that 25% are numbers that we've never seen any basis for. And, from our standpoint, and I think from consumer standpoint and provider standpoint, everyone who cares about this program is against fraud. Nobody wants...
If I could just stop you, Mr. Mecca,
Sure.
because I don't want to have a debate about it. I just wanted to point out the existence of the report. And it's my staff actually just gave it to me, Quality Assurance, Quality Improvement report that came out in 2008. That's the one you were talking about.
That's an analysis of the initiative that you put into place in 2004 that actually shows that the incidence of fraud is relatively low.
Yeah, that's
probably comparable to most other programs that we run.
Because we had a lengthy discussion about this in conference committee, and I know we've had this debate off and on for a long time. But there is this report for people that can want to take a look at it. But that is really the genesis of how we got to this legislation and how we got to where we are today. And it's not to say that this is not an issue and that we shouldn't be doing this, but we need to be making sure we're doing it in a rational, non-chaotic way. Mr. Cheney had one final question, and then I'm going to go to the department.
Well, it's just Mr. Swanson's comments reminded me, and I don't know if somebody asked this or commented on it before, but the part of this policy that I found the most objectionable was the fingerprinting of the recipients. And I was just wondering what the status of that portion of this is, and what planning is that, and how much is that now thought to cost? I mean, I think in July, when the administration said, they had to have that, and somehow that was going to prevent fraud, which most of us had trouble figuring out how the two were related. But nonetheless, the biggest fear most of us had was that was going to cost more than it was worth to implement. And I don't know if now people, in the course of whatever you've had to do, have had time to figure that out, or have there been any directives on that one? Or
I think
what?
we'd like to defer to the department. We haven't begun to talk about
They haven't talked
finger
about that
imaging
yet.
and fingerprinting of time cards and a host of other things that were in the statute.
What was the date for that? Then that wasn't in November. It was next
July
year.
and November, but various implementation dates. But
now November?
Oh, I'm sorry. Next.
2010. Okay, so we have time to worry about that problem.
Well,
it's not
but
like
not
imminent.
a lot. I mean, if
No,
we're
but
going to we're going to put in a place.
we also
to
have time for Mr. Swanson to correct it before next year's budget.
Not a lot of time. If we're going to fingerprint every recipient and ask recipients and providers to put a wet print on every single time card, there's a whole host of issues that need to be addressed, and we should be working on that right now.
The most important one right now, before next, is to figure out what you estimate that will cost, so that we can start to figure that out and use it in the early part of the budget discussions next year if it isn't trying to be implemented before. I mean, I was worried about the implementation date, but if it's farther out, it gives us more in a minute to
I think
figure it
it's
out.
important to underscore one last thing. We have, under current law, a provider enrollment process. There is a provider enrollment form. We have public authorities that do criminal background checks. There are registries. It's not like we have nothing under current law. And typically what happens when you change the law is the prior law continues until we're able to implement the new law. And what happened in this case is the administration cut off current law and said, as of November 1, you can't use the processes that were in place before. You have to use the new processes, even though we know you can't start the new processes.
But that's just the implementation. The law hasn't.
That's what's unique about this situation.
The law has not actually changed. If the department is refusing to implement current law, that's different. But the law did not change. The underlying law was not repealed, was it?
Well, let me just step in here because we're going to have a discussion of legal semantics. But I think the point is a good one, and it's one that I try. Well, maybe not semantics, but implementation of law, and whether one overrides another. But what I wanted to point out is that something I pointed out in my opening statement is there's been a catch-22 here that has been created, where you can't comply, providers can't comply, recipients can't comply, and yet the benefits are going to be cut off because they can't comply by a certain date. A date which was requested by the administration. So I think that's a perfect intro to having the department come up to talk to us, make their presentation, answer some questions, respond to some of the issues that were raised. And in the interest of time, I'm going to ask John Wagner, who's the director of DSS, and Ava Lopez, who's the deputy director of the Adult Program Division. And in the interest of time, I'm going to also ask Ginny Bella from the Legislative Analyst's Office to come up at the same time. So we won't go to her for a separate presentation, but she will be here as a resource for members who have a question of the LAO's office. So, Mr. Wagner, we'll start with you.
Sure. And I know that the committee had a couple of questions about the enrollment forms and the criminal parts of the new law, so we will also be joined with the Department of Health Care Services as well. Having said that, before I get into my statement, there is a handout that we provided the committee called a critical priority list just to follow. I will be addressing that. And I'll give some opening remarks and address some of the questions, and then I'll be followed by Eva Lopez, who will address some of the issues identified earlier. I want to thank you, Madam Chairperson, and members of the Assembly and Senate Budget Committee for allowing the Department an opportunity to discuss the implementation of the 2009-10 budget law from the 4th Extraordinary Legislative Session. As you are aware, this bill was passed by the legislature and signed by the governor in late July, calling for some very significant program reductions and changes in order to address the significant fiscal crisis facing California. These changes were and are complex, as evidenced by the many variations of proposals that staff worked on through a very iterative process, both from the executive branch and from the legislature, during the extensive budget negotiations. This is no more true than in the state's in-home supportive services, or IHSS program, which is a critical component of the state's strategy for long-term care. Part of this is evidenced by the team of folks who are here today to answer questions drawn not only, as I mentioned, from the Department of Social Services, but from the Department of Health Care Services as well. The IHSS program is inherently complex given the evolution from a social services program to a predominantly Medicaid program over the years, thus involving not only state laws governing IHSS, but laws governing Medi-Cal and federal regulations in Medicaid. I want to highlight some of the efforts to date to implement the changes as spelled out in the budget law. After that, I know that Eva will be able to address some more of the specific questions, and Healthcare Services will also be addressing some of the issues that staff highlighted as wanting to be addressed. For our planning and implementation purposes, on the handout that was provided, we've grouped all of the changes as contained in the budget law into 9 categories comprised of 20 specific priority activities. This budget puts forth some very aggressive timeframes for many of these activities. 4 of the 9 categories are required by law to be implemented either by enactment of the budget or on or before November 1st, 2009. The 5 remaining categories of activities, some of which Senator Ducheney was asking about, have a implementation date beyond that. Though we have done some work on these longer-term activities, understandably the bulk of our work, focus, and resources have been directed to those requiring implementation by November 1st. The first of these 4 categories for these short-term reforms involves the budget reductions necessitated by the fiscal crisis facing our state and the country. The specific activities comprising this category include implementation of reductions to the public authorities' administrative funding, elimination of the IHSS share of cost buyout or supplementary payment for medically recognized services program, and the reduction in services as tied to the functional index score and rank for the purposes of domestic and related services. The state has been enjoined on the service reduction, and there is open litigation on the elimination of the supplemental payment for medically recognized services. So we are not prepared, as the Chair recognized, to speak in depth on these activities. The second category of activities relates to those aimed at fraud prevention and detection, including mandated changes to the IHSS timesheets. The first item in this category that went into effect upon enactment of the trailer bills included a $10 million investment in state funds for prevention, detection, and referral of program integrity or anti-fraud efforts. CDSS drafted and sent letters to all county boards of supervisors on September 25th outlining the process for which counties could request funding for IHSS anti-fraud efforts. The second activity in the anti-fraud category of reforms was the requirement to change the standardized provider timesheets. In addition, the budget law provided additional resources of just over $4 million in general fund for county and state staff for various anti-fraud activities. Department fiscal staff have been working on these allocations, and we expect to get the county financial or the fiscal letters out this week. The third category of activities involves establishing a new provider enrollment process for IHSS.
What are you trying to get out this week before Sunday?
The county fiscal letters, the question was raised earlier about the allocation of some of the resources. The county fiscal letters would go out allocating the resources of the funding.
They're supposed to do something with it by next Monday when you give them a letter on Friday?
No, this is related to the requirement that they have been working on a plan since the letter went out in September. The third category of activities involves establishing a new provider enrollment process for IHSS, which we are required to do by November 1st. Changes in the provider enrollment form have been in the works for several years, including the requirement to sign enrollment forms under penalty of perjury. Prior to this year's budget bill, CDSS had been working with stakeholders since the passage of SB 1104 on establishing a new provider enrollment form. We have also been working with healthcare service staff to ensure the revised form includes all necessary elements the state needs in order to comply with federal Medicaid requirements. This is an area where the evolution of the IHSS program into a Medicaid program has factored into the changes of our enrollment activities. These decisions have been informed by stakeholders and requirements found in SB 1104. In addition, it's been informed by the budget negotiations and laws enacted as of July, the Medicaid regulations, and state Medi-Cal statute. The department has issued both an all-county information notice, as was mentioned earlier, and an all-county letter. We were recently informed via a demand letter received on Friday that the state is involved in pre-litigation regarding the provider enrollment form, and the administration is currently reviewing our legal options. The budget law included a new provider orientation as part of that process that is effective November 1st. Under law, new providers will have to undergo an orientation that contains a number of requirements as spelled out in the law that covers the IHSS program. Current or existing providers have more time to undergo this orientation, though it must be completed by July of 2010. Given limited resources, DSS produced a video on these new orientation requirements, which was released to counties on October 15th, and has developed hard copies of the orientation materials. We are working to ensure the materials are available in languages other than English. In addition to requirements on the provider end, the budget law includes a new recipient enrollment process, which is the fourth category of activities that are required to be implemented in the short term. The department will be working with various stakeholders to establish protocols and procedures covering the recipient enrollment process, providing for an ability to collect fingerprint images for recipients whose assessment occurs on or after April 1st, 2010, or for recipients in the program by that date to occur at their next scheduled reassessment. Before turning it over to Deputy Director Eva Lopez, I'd like to conclude by acknowledging the breadth of reforms in our IHSS program as spelled out in the budget law. These reforms are certainly and undeniably some of the biggest challenges we've made to the program in years, and our timeframes in which to do them are extremely tight and aggressive, which was articulated to those involved in negotiating this budget agreement. Understandably, this information was balanced with the need to also address the fiscal pressures in preparing the budget. The department has endeavored to meet these aggressive timeframes to the best of our ability given our resources, and we know our county partners are doing the same in putting forth their best effort to implement significant reforms in as timely and responsible a fashion as possible, and given state law. We acknowledge that these timeframes are tight, and we're striving to meet the timelines and requirements as spelled out in the law, as well as the needs of the counties. We know that there continue to be issues that we have, and we'll continue to do our best to address them. We know this process, given the aggressive timeframes, has truncated some of the traditional stakeholder review processes the department has employed over the years. But we are open to clarifying where we need to clarify, working with you and others in addressing the concerns of our county partners within the confines as spelled out in law. I thank you for the opportunity to be here today and answer questions.
Thanks, and I really appreciate your statement of desiring to cooperate, but I have to ask the question before we go on to Ms. Lopez. What are you going to do on Monday?
We are Deputy Director Lopez will get into many of the specific components. We are doing what we can to provide the information. One of the things that Deputy Director Lopez is going to walk through is a process in which we will be able to reimburse approved providers who are signing up as of Monday and haven't been able to complete the process, and we're prepared to address some of those issues.
Okay. Ms. Lopez, please. Well, you know what, Senator, we'll go to questions soon, and I'm taking a list, so you'll be top, and then Ms. Alquist, and then others. Yes, Ms. Lopez.
Good afternoon, Madam Chair, members. Eva Lopez from the Department of Social Services. As Director Wagner stated, there in fact has been a tremendous number of documents that have been drafted by the department and released to the stakeholders, either in the form of draft all-county letters, draft all-county information notices, and ultimately final instructions to the counties. Consistent with many of the statements that have been made, this daunting task, we have in fact endeavored in the state to provide as clear as direction as possible to the counties, and as such we have released approximately a total of 8 draft all-county letters, And we have finalized 6 all-county letters so far, and we have released the Board of Supervisor letter, as Director Wagner mentioned earlier, and we'll be finalizing the remaining all-county letters this week. CDS wants to assure the members that we have reviewed all the comments that we have received in regards to all the draft all-county letters, and we have modified the all-county letters as appropriate. However, if there's still need to provide further clarity, further clarification, we will in fact be submitting or releasing subsequent all-county letters to ensure that counties are clear of what the directives are. There have been, like we said, a large number of comments provided by the stakeholders, specifically in 3 key areas: provider enrollment, provider orientation requirement, and criminal background check and appeal process. And at this point, what I would like to do is go over the key issues that were included in page 8 of 10 of the background paper that was released by the members earlier on Friday. And it's page 8 of 10. It's the background paper. It was concluded. It's the issues that were brought forward, and I wanted to respond to those issues.
Yes, the Assembly Budget Committee background paper?
Yes.
All right.
Correct.
And
I'm
what
sorry.
What page was that again?
It was page 8 of 10. And what I'm going to do is I'm going to respond to each one of those issues. Many of these responses will touch on many of the things that Mr. Mecca brought forward in his presentation. The first bullet, it mentioned in terms of ensuring that we provided important information for both current and new providers in terms of the process distinction, because there is a distinction. And although we endeavored for the all-county letter to be clear, and that it was quite well understood by the counties, if not, we will in fact be releasing subsequent all-county letters at a later date if we haven't been able to provide them clear instruction. The second bullet mentions, in terms of one of the all-county letters that we released, mentioned that we were going to be releasing a subsequent all-county letter, and of course that created some concerns or some questions. And yes, that all-county letter, which was 09-52, discussed the provider enrollment process and transmitted the revised enrollment form as well as other supporting documents for the enrollment process. However, the subsequent all-county letter that in fact will be released provides detailed instructions on the other requirements, such as the criminal background check process and the list of misdemeanor crimes that disqualify an individual as an IHSS provider.
Well, let me just stop you here, because there's an entire page of bullet points here. Are you planning to go through all of them? Because I think that's getting into a lot of detail, and this committee is really concerned with the overall implementation of this program and what's going to happen on Monday when benefits get cut off. So I don't want to necessarily stop you from testifying, but I do want you to address the overall question.
If I may then, what I'd like to do is, because some of the responses and some of the issues that were brought forward in this document, again, are very consistent with what Mr. Mecca brought forward earlier. So I would like to at least go through those. So
I'm not going to let you go through every bullet point.
No, I understand that.
If the department wants to respond in writing to each of the points that have been raised, that's entirely appropriate, but we have a whole committee here of members that have lots of questions and a lot of issues that have been raised with respect to the ability of the state to implement this program in a way that doesn't cause human harm. And that's what we need to talk about. That's why we want you here to tell us what you're going to do.
Right, and Madam Chair, I think we can get to that. I mean, to be very clear that this, when we were invited to this hearing, we asked what it is you would like us to address. These issues reflect what we were told you wanted us to address. If there's items in here you'd like us to rework or focus on, happy to. I think probably the most pressing one is your earlier question about what happens on Monday. Right. And I think some of the issues that were identified in the earlier testimony regarding provider enrollment forms and a process in which the length of time with the Department of Justice and others is probably one we should maybe start with, because that seems to be the crux of some of the business changes on Monday.
No, what I want to know is what the department is going to do about the people who will not be able to get their providers on Monday. We're going to have elderly disabled people in their homes with no providers, and you told me that the department will be looking at a way of reimbursing many of these people, most of whom get paid minimum wage and are on the verge economically already. And simply can't afford to wait around until the department decides to reimburse them. And we'll be looking for other jobs, undoubtedly. So I want to know, we've got a crisis on our hands. And, you know, we've got to bail out the sinking boat really quickly. So that's what I want to know. I appreciate that you need to get into details, but that's not the forum here. You need to do that with the counties. You don't need to do that in a legislative oversight hearing.
Well, but again, these issues were the ones the committee identified.
Well, the committee issued a lot of paper, and I'm not going to sit here and have you go through every bullet point. You can respond in writing to every one of those points, and I'll make sure that all the committee members get that. So what I'm going to do at this point then, unless you want to address that overall issue, I just can go to questions, and committee members can pose their specific questions to you. So let's, I have a list here, or I had a list.
If I may, I mean, understanding the need not to go through each one of these bullets, I think maybe if I just hit a couple of points that you have, in fact, discussed during the actual hearing in regards to the process of the distinction between a new provider and an existing provider. I think that's an important piece that we need to make a statement and will be, in fact, released to the counties. And that is whether or not there is a distinction between the two, and there is.
Yes,
new providers will have to go through the process effective November 1st, correct?
I think we're clear on that.
However,
let me stop you, please. I'm sorry, but I need to keep control of the discussion here. And what I'm hearing from my members is they want to go to questions. And so I will allow that to happen, and we'll let you answer the questions. And, you know, honestly, I don't want to set up a forum where we're fighting here. I really want to have a feeling of cooperation and a way to figure out how we're all going to meet what I believe is a mutual interest in serving the people that are on IHSS. And I think that is our ultimate goal here. So I don't want to set up, you know, some situation where we're cutting each other off, but I do want to allow committee members to get answers to their questions, because that is the purpose of this. So I have a list. I'll start with Ms. Alquist, then go to Ms. Ducheney, Mr. Leno, Mr. Swanson, Mr. Nastande. All right, then Ms. Alquist.
Thank you very much. First thing I'd like to do is to frame the issue, and I understand that there are 360,000 IHSS workers statewide and 450,000 recipient consumers. And what we're really talking about during this great recession that we are experiencing is a case where, first of all, the provider, come Monday, is going to be expected either to volunteer their services and not to be paid, or to have the recipient pay for the services, or maybe eventually to be reimbursed by the state, which seems very almost impossible. On the other side, the recipient is going to be faced with a situation where he or she may not be bathed, may have soiled bed sheets, may not be provided meals, and may not be able to have help to getting in and out of wheelchairs. Those are just a few of the things, and having been a caregiver for many years of my life with 4 different people, I understand what that really means, and a lot of people here today really understand that. So given what's going to happen Monday, some things I need to say, and I have worked with the department for many years in different capacities. I don't see where you are claiming any responsibility or accountability for what is going to occur. You're telling us about sheets and whatever, but we're hearing back from the counties, and Mr. Bell, Assemblyman Bell, and I share a lot of Santa Clara County, and Santa Clara County, which I think is really exemplary in what they do, is saying to us that in terms of the instructions, they are not being given complete instructions. The instructions they are given are contradictory, and that they're not even being given information in the appropriate languages, specifically in this case for Santa Clara County, Spanish, Vietnamese, and Russian. Now, if I were to hold up something and it were a combination of classical Greek and Tahitian or whatever, I doubt that many people in this room would know what to do, even if it was clear and concise and complete. So what I want to know, and I have 2 or 3 different questions, what I want to know is, when are you going to fix this?
As it relates to the translations, We are working expeditiously to get all the translating materials for any and all the forms and letters, and we're looking at having all those translations completed by next week and released to the counties.
And what I would suggest, in addition, that it should be complete information. The information you need to get to all the counties would include complete information that is not contradictory, and that is also in all the languages that are appropriate to this.
And we agree there will be in all the languages that are part of our threshold, and that would be Spanish, Armenian, and Chinese. In addition to that, we will be finalizing the remaining all-county letters this week with further direction and instruction. We believe we have provided clarity based on many of the comments that we have received so far.
And that included Spanish, Vietnamese, and Russian.
And our threshold for the for our program currently is Spanish, Chinese, and Armenian.
Okay, then I think there's going to be some problems with some of the counties, and I hope that you will get a letter to the two chairs, to Ms. Evans and Mr. Leno, both of the Assembly and to the Senate, in terms of what you are doing and when you are doing it. What I would suggest also is that it's obvious to me that some funding is going to need to be restored, and it's going to be needed to be restored in proportion to the resources that need to be provided. And I think you really need to articulate to the chairs what it is that you need to completely do your job, because I think you are people of good intent. We are way behind, and there's no way come Monday that the providers will have the information that they need to give you the information they need. And we know that this is a catch-22 vicious circle. So as soon as you can articulate what the counties really need to do, and also articulate to us, hopefully by next week, how much time and money we're really talking about, there's no way people are going to have the services that we all know that they need. People will die. I'm not being dramatic. People will fall out of wheelchairs or when they're going to the bathroom, what have you, and I won't talk about the other possibilities, but you know what they are. And so we need to really know how soon you can get complete information to the counties, with a copy to us of when that is going to occur, and what resources you're going to give to the counties, what resources the state. I know we're in deficit again, but this is a program we are really responsible for.
To address both your questions, in terms of the complete information, as I stated before, the remaining all-county letters will be released this week, which will provide clarity and instructions to the counties. The second question, as you had, is regarding the funding or the resources needed for the counties to be able to do this. It is our intent and hope that we will be able to release the fiscal allocation letter this week.
Thank you very much.
Thank you. Mr. Cheney, you're next.
We here now. That's all right. I changed spots. This is sort of boggling. I guess we keep trying to get back to the really simple question the chair asked. What is going to happen on Monday? And the issue here, it seems to me, and nobody's sort of talked about this yet. First of all, your language list, I don't know where you got that, but in schools, Vietnamese comes second. So I can't imagine that in your world, Armenians, I mean, I appreciate the need for Armenian and Chinese, but I would think, as Zakwas noticed, Russian and Vietnamese, probably Hmong, are also critical in certain counties. And it'll be different in every county, but I can't imagine not being able to not to have that. But I get the real question here is very simply, do you believe you have the legal authority, as many of us believe you do, to say, we're working on implementing this. You got all of the letters that you've put out to date, as far as I can tell, are under legal challenge, or somebody's decided, either the legislature, the LAO, or the counties all think it has errors in them. All of the ones that are in draft and are still in draft form. You don't have forms and languages. You don't have the orientation materials got to people 2 weeks ago, and you're asking the counties to figure out how to redo their entire systems in a week. Everything here says this isn't going to happen that day. So what's the ability of the department to say, these are the things that have to be in order before this can be implemented, and we're not implementing, nothing goes into effect, nobody gets thrown out of the program until those 6 things, whatever those are final, are there, and exist. And then your dates are fine. Whenever you get it together by November 15th, fine. You get it together by December 1st, fine. I'm not quite sure that can happen, but we need to understand what are all the steps, what are all the procedures, and you need to do it like a plan that says we're going to have these are the 6 things that have to happen in order to actually do what this bill says, and this is the timeline in which we're doing. I mean, I think and the counties, you cannot throw this on them. This is just sort of, if I were them, it's like mass rebellion here. There's no way they're going to do this. So then the question is, are you throwing it on them to just tell the people, well, sorry, you can't do this? And is that really where finance got you on the cost savings? Is because they really thought you just dumped 90% of the people like the governor originally proposed, since the way you were doing this was going to result in the same thing?
To answer your question, Senator, we are doing the best.
Sorry. I need the audience to not respond, please, because we've got a lot of questions and a lot of answers that need to be given. So let us do our business, please. Thank you.
We are doing the best to our ability to make the timeframes as spelt out in the law. I think for the way you've posed your question, it would be helpful to look at from a recipient's perspective what are the different pieces that are going into effect and where we're at. We try to do that through the process, but maybe if we do it from the recipient's perspective. So for that, in the following way, first of all, there's a group of recipients impacted by the court order where the counties are working on the workaround. We should talk about the status of that and how that's going to work. And I know it got a chuckle, it warranted a chuckle. This was not the situation where the state made changes and then said they couldn't undo it. The court has a attestation from our vendor EDS that it takes 5 minutes to make, or 5 weeks, up to 5 weeks to make these changes in the system, which were done. And the injunction came after those changes were done, and the court order requires us to implement this much sooner than the 5-week period. So EDS is not an avenue for us to get these folks back enrolled in the system, which is why it relies on the county worker to do it. It's not a question that the state can't do it. The system takes up to 5 weeks to reprogram.
What makes you think the counties can do it in less than 5 weeks?
Because the work is very different in a manual than looking at the whole reprogramming the system. And again, this is a vendor issue. They have a declaration to the court and the order. We have tried to be very creative with them. So why don't we walk through the court order and the recipients, current recipients, new recipients, and address some of what will be happening from that perspective.
And going to your question on what's going to happen on Monday. Right now, on Monday, if new providers come in the door, they will have to complete the new provider, not only enrollment form.
That means effectively you're saying there will be no new providers in this program for another month, because they won't be able to do that. So what are you going to do for that month when they really can't create new providers?
First, it's important to understand.
You've made it impossible for them to comply. I mean, you can't ask them to comply with something that we, the state, not just you, can't ask them to comply with something that doesn't exist.
Again, I think, the department is moving as expeditiously as possible to implement the laws that were passed by the legislature and approved by the governor. We are striving to provide the counties as much information and clarity so that they're able to implement this come Monday. The question of recipients not being able to receive services. Right now, currently in our process, we have, as we all know, our population, there's 60% of our population are services are provided by family members. We currently have processes in which family members do in fact provide services and receive retro payments. So the processes are there and in place, and it's the intent if the providers, the new providers that come in and they're not able to go through the process in order to get paid, they will in fact receive retro payments.
And I think that's part of the frustration, though, that's being expressed by Mr. Cheney and that I alluded to a little bit earlier. There will be a gap. That's undeniable. And these are folks that don't have resources of their own to fall back on during that time. They will go elsewhere, and there will be people that are not able to get their services and are disabled and are elderly and aren't able to function during that gap of time, and that's what we're worried about. And I think that's what the counties are trying to figure out. How are they going to take care of this situation? And if we've got a computer that's set up to deny benefits automatically as of Monday, there's going to be a lot of fallout from that, and that's what we're struggling with. That's one issue we're struggling with, trying to get a grasp on what we're going to do with that. The other question being, how are we going to implement this in a little more orderly fashion? And there's a lot of people here that have questions, so I want to give them a chance to voice those questions. I have Mr. Leno, Swanson, Estande, Nielsen, and then Bell. So just that's my overall goal. So that's what we're here to try to discuss. Mr. Leno.
Thank you, Madam Chair. I was going to ask some of the same questions that have been asked with regard to the 5 sets of instructions that Mr. Mecca said that are needed by November 1st are not yet finalized. You say you'll have them by the end of the week. Clearly, there's not going to be implementation. Senator Cheney's pointed that out. I would like to ask you some questions about what I believe is an abuse of discretion relative to the legislation that was actually enrolled into law and how it's being implemented. There are about 5 different issues. And I'd like to start with the list of offenses that would bar a prospective provider. SB 1104 from 2004 lists a number of them: fraud against the government, health care or supportive services program, elder abuse, child abuse, and there was a time frame of 10 years. So one could have a clean slate after 10 years. But the new provider enrollment form released recently relies on previously enacted Medi-Cal statutes, and it bars providers for any felony and serious misdemeanors. And as chair of the Public Safety Committee, I don't even know what a serious misdemeanor is. So I wondered if you could please inform me.
The folks that have joined the table are our colleagues from the Department of Healthcare Services, and you're right. The current law lists a set of 3 types of crimes in 12305.81 that bars certain individuals from becoming in-home supportive services providers. The problem is that the issue is that there's other laws that impact the IHSS program, and I would like Healthcare Services to address the crosswalk between those other laws.
My name is Raul Ramirez. I'm Chief of the Provider Enrollment Division.
Microphone on.
Sorry, my name is Raul Ramirez. I'm Chief of the Provider Enrollment Division within the Department of Healthcare Services. In regard to the application of Welfare and Institutions Code, Section 14123, which in essence delineates that any felony conviction precludes you from participation in the Medi-Cal program, reading Welfare Institution Code Section 14123 and W&I Code Section 12305.81A together, it's clear that the legislature did not constructively repeal Section 14123 by enactment of Section 12305.81A, as the statutes are not inherently inconsistent. 14123 controls under what circumstances a Medi-Cal provider is excluded or suspended. Specifically, you are excluded from participation if you have any felony convictions. It goes on to say that any misdemeanor involving fraud, abuse of the Medi-Cal program, or any patient or otherwise substantially related to the qualifications, functions, or duties of a provider of service may also result in exclusion or suspension. Section 12305.81 controls under what circumstances providers are excluded or suspended from the IHSS program. Specifically, it reflects the 3 specific grounds or crimes for which you are excluded or suspended. The crimes enumerated under 12305.81 are likewise grounds to exclude providers from participation in the Medi-Cal program under Section 14123. To the extent IHSS providers will be reimbursed with Medi-Cal dollars, IHS provider enrollment must be conducted in compliance with state and federal Medicaid and Medi-Cal laws, including provisions of Section 14123.
Okay. Thank you for the explanation. We have a very different understanding of it, and our Ledge Council points out that since this is later enacted and specific to IHSS, that your arguments do not hold. But let me go on to the next point.
Senator, could I just add one thing?
Sure. Go ahead, Mr. Wagner.
I just want to acknowledge that the administration has in the past and has recently offered to work with the legislature if the legislature wanted to address current state law in that area.
That's probably a good suggestion.
If California chooses to establish a different standard for IHSS providers, federal regulations do allow flexibility. However, that's provided that federal minimum requirements are still met. And those federal minimum requirements are under Section 42 CFR 1002.210.
Very good. And then if you could clarify, and I think you were approaching this as we went directly to questions, who has to attend the orientation and who can be delivered the information?
As part of the orientation, I'm sorry. As part of the orientation process, the new providers coming in the door will have to have completed the new provider enrollment form as well as participate in the orientation. However, existing providers have until June 30th of 2010 to complete the enrollment process, which also includes the orientation.
But the information you've been sending out almost exclusively states that all providers must attend the orientation.
The final all-county letter on the provider orientation, which is scheduled to be released today, and will in fact be very clear that existing providers have until June 30th of 2010 to complete the enrollment process, which includes the orientation.
And does that include attending the orientation or not for existing providers?
What the existing providers will have an option. They will be able, we will provide them the CD, a CD-ROM, and or the hard copy package of the materials that they can take home and watch at home, and then they will need to come back to the office, as one of the requirements is that they will have a face-to-face meeting with the social worker to provide them a copy of their Social Security number and driver's license by 2010.
Can you minimally acknowledge that information you've been distributing has caused confusion and disruption?
I acknowledged in my testimony that there is a concern over, and we readily admit that given the aggressive time frames, we have had a very truncated stakeholder input process, and there hasn't been the level of clarity that the state or the counties would like, and we are endeavoring to address those questions and issues as they're identified in some of the final ACLs that Eva just mentioned, as well as continuing to work on areas where it needs to be clarified.
Okay, very good. And I do want to recognize that you're operating in as an extreme situation as the counties are, that we have laid on you timeframes that are completely unworkable. And we must take some responsibility for that too, but as has already been discussed by Mr. Adams and others, we had a gun to the head as well. With regard to the new provider enrollment form, you were about to answer that question, I think, earlier, that for the 350,000 existing providers, what is required of them?
Again, for the existing providers, they will have to complete the new provider enrollment form and go through the orientation process. However, They have until June 30th of 2010 to do that. Plus, they will be able to take the materials home for them to complete the form itself and to view the CD-ROM and or read the materials that are tied to the CD-ROM. However, they will have to come to the office in order for them to have a face-to-face and provide a copy of their Social Security card and the other documents.
I think I'm speaking for most of committee members that it was our understanding that there was an agreement with the administration that for the existing 350,000, since they already have forms on record, they would not need to complete the new forms.
If I may, I'm sorry. It's always the case when you're looking for something, you can't find it. Forgive me. We went back and we looked at the particular section, the W&I code, and if I may, W&I code 12301.24, parents little c. Between November 1st, 2009 and June 30th, 2010, all current providers shall receive the information described in this section. Following receipt of this information, a provider shall submit a signed agreement consistent with the requirements of this section to the appropriate county office. And as we read that particular section of the statute,
form?
It's the signed agreement, the enrollment form, and going through the orientation process.
I'm not sure that is the enrollment form section.
Section 12301.6, and it speaks to the current providers, the signed agreement, and then that's why we view it and interpret it as the completed form and the orientation process for existing providers will occur. However, they have until June 30th, 2010 for this to occur.
We'll come back to that in just a moment.
Okay.
With regard to the unannounced home visits, the legislation was very specific in that it targeted cases where there is reason to suspect fraud. But you sent out a notice that all recipients of impending changes to the program without consulting counties or including information about targeting of cases or follow-up efforts. It's just said that in order to promote program integrity with IHSS program effective immediately, recipients may be subject to unannounced home visits from the county or from DHCS audits. There's a significant discrepancy between what the legislation says and what your ACL stated.
The all-county information notice in which we provided to the counties information on what the notice would say. And when we say advising the recipients and the providers, allowing them the knowledge that it may occur that there would be unannounced visits. When we actually go through the process, which as part of the statute, we will work with the county welfare directors in order to establish those protocols, we will in fact be targeting those potential cases in which fraud may be occurring. But however, when we released that notice, it was to enable all providers and all recipients to understand the new changes that were occurring within the IHSS world. And that's why we said may, an unannounced visit may occur.
And you've already heard some actual accounts of how that has impacted consumers, afraid to actually leave their homes, that they might lose their services. And I guess that would be yet another unintended consequence of the truncated stakeholders process, but it's really had a very detrimental effect.
One of the things that, as we work through the protocols for these unannounced visits, we will, in fact, be working with the counties, and it's not our intent, if we do an unannounced visit, that it will immediately create a situation in which the provider is discontinued and or the recipient. There will be multiple attempts to reach them and to schedule those, to let them know that within a period of time there will be an unannounced visit, but we want to ensure and assure the members, as we will with the providers and recipients, that if we go, if the unannounced visit occurs one day, it does not mean that that case will be discontinued within that one day.
I appreciate that. Those kinds of things need to be in writing somewhere. Mr. Leno, did you have?
Yeah, just to complete then, going back to this last issue of the existing providers and the prospective providers. In Welfare and Institutions Code, Section 12305.81, that is the enrollment form section. We believe you were reading from the orientation section, and that in the form section, enrollment form section 12305.81, existing law, we didn't change it. It reads that the department and the State Department of Health Care Services shall develop a provider enrollment form that each person seeking, and that would be the operative word, to provide supportive services shall complete, sign under penalty of perjury, and submit to the county. So that's the section that you should be concerned with regard to existing providers.
We have
the
some
enrollment form.
We have some legal staff taking notes, and we will look at that. Thank you, Senator.
If you could. Thank you for your time.
Thank you. Mr. Swanson, then Mr. Nastande, Mr. Nielsen, who seems to have left, and then Mr. Bell.
Thank you, Director Wagner. Do you acknowledge that this is that we're in we're at a point of crisis in terms of the implementation of this program, and is your department or administration preparing any specific instructions on forbearance or modification of that will help with the administration of the program and provide the time for a orderly transition that will be communicated to the counties within the next 72 hours or so?
Well, we acknowledge, again, that the budget as passed by the legislature and signed by the governor includes very aggressive timeframes. From the state's perspective, we're doing all we can to implement those the law in as clear and responsible and swift a way as possible. And we know that the counties are facing similar pressures and similar expectations. We don't have the authority to not implement the law. We're doing our best to do it. We can't. We don't have the authority to change the date. If the legislature looks at changing statute, that's your prerogative, but it's not the department's.
Yeah, but no, I think I'm asking whether or not the administration, you're on the front line on this question. If you see that people are going to be harmed because we passed a bad law, or it's not practical for its timely implementation. The question is whether the administration either ask us or work with us to take such steps. And then as people that are implementing, it seems incumbent upon you to communicate that this is not workable, or there are steps that need to adjustments that need to be made. And so, I mean, your answer kind of implied that that's not your role, so you're not doing it. And is that accurate, or?
Our role is to implement the law that we are charged to implement. Having said that, we do very much value the suggestions that the counties have raised, the issues that they've identified as needing additional clarification, the issue identified earlier of current providers who switch recipients and therefore become caught under the new provider enrollment process. We're very sensitive to the volume the counties are facing, and we want to accommodate trying to mitigate the number of folks that are coming to the local offices. That's an area where we feel that we can provide those providers to be current providers, so they don't have to go through that new process.
Did you say that you do acknowledge that this is a crisis in terms of our?
No, what I'm saying is the timeframes are very aggressive, and the law is that we meet these timeframes to the best of our ability, which is what we're doing.
Your statement, your opening statement, said that IHSS services that are a critical part of the state's long-term care strategy. And so the question that I have for you, I just don't want to pass up this opportunity to give you a chance to comment on it. We're by all projections facing a $7 billion to $10 billion deficit next year. Given this experience, are you suggesting that the administration's position or the position of the department is that future cuts in the IHSS services in this crisis that we're going to be facing over the next 2 months, in the coming months, that it would be your department's recommendation that no additional cuts be made in services, since it's a critical part of the long-term care strategy?
Well, as you can imagine, the Department of Social Services administers many critical programs given the nature of our mission and those we serve. I think that the budget crisis facing the state of California has hit all programs, all services, all departments, and certainly ours. And we will continue to endeavor to work within the governor's budget process to make sure that information is provided as the governor prepares his budget, which will be unveiled in January.
Yeah, well, I hope we could have an honest analysis of the impacts that are taking place here. And I hope that the counties that are testifying will be very clear with us about the unfunded mandates that are created by this law and how much money they actually have to spend. And so in the atmosphere of billions of dollars that we're cutting, that we have to cut, to take $400 million and make a cut that ends up having $1 billion of impact is not wise. And so it seems to me that I hope that the counties will be clear to us about what these costs are. And I think that it's also incumbent upon the administration to say, from your own analysis, whether or not it's wise for us to consider these kinds of cuts that provide these kinds of services. And so I don't think it's easy just to dismiss it as only our responsibility. I think that it is the administration's responsibility, as well as the counties, to help us understand the impact here as we go forward. Because I don't think, from my analysis, I never thought that this amount of cut, this $400 million, whatever the final number ends up being, that in fact it's worth what we're going through now and the impact that it have on the people that the program is supposed to serve. And so that, to me, that's part of it. It's not, people are being affected here, and I think that there are moral issues involved. And I think that if we implement a policy, and particularly given the numbers that we're working with, we need to understand the full ramifications of that policy and some cost analysis of that. And I'm not, as I said, I just do not see how this represents cost savings when you calculate all those impacts.
Thank you, Mr. Swanson. We're going to go to Mr. Nastande, then Mr. Bell, and then I'm going to wrap this segment up by just making a couple of comments and throwing out a couple of suggestions, and then we've got another panel to go to and finish up by 3:30. So, Mr. Nastande.
Thank you. Are you willing to talk about the functional index? Okay. If you are you guys comfortable with the implementation of that if the judge's stay is overturned?
I don't think we would be able to have that discussion because of the injunction that we currently have. We could talk about what we're doing in order to implement the excuse me?
Was it the same thought process that went into the functional index as went into these other parts? I guess my question is, are you comfortable with feedback that you've gotten from the counties and so on with that, to where if you go forward it'll be smooth sailing, or do you anticipate these type of issues coming up as well?
Just so I'm clear, are you asking whether the comments that we had received when we ultimately finalized the all-county letter that dealt with the IHSS service reductions, whether those comments are things that we will consider and look at in any future as we go on, as we go forward? And if that's the question, yes, we looked at the comments and we have considered them when we finalized the All County letter. And now, because of the order, those reductions will not occur effective November 1st because we have a temporary, restraining order to do that.
Mm-hmm. Yeah, and I had received comments from different folks back in the district that maybe all counties weren't on the same page as how they would be using that index. Are you comfortable that they are all clear on that and they will be using it uniformly?
I don't think we can answer that question given the litigation currently before us.
Okay. Question to the LAO, if I may. Do you have an opinion whether or not the contract mode versus the IP mode, if there would be cost savings?
I'm sorry. I didn't. Ginny Bella with the LAO. I didn't hear the difference between what two things?
Yeah, the contract mode versus the IP mode.
Oh, I see. I think you're talking about whether or not the providers are through an agency or if they're an individual provider that's hired by a recipient. I think when we've looked at that at the past, and the LAO has not done a formal study of that, the contract mode is more expensive per hour than the IP mode.
However, there's less hours. You got to look at the whole picture.
And
there's
that could
less
be
hours done. So what's the gross?
Right, and that would be the analysis we would have to do that we have not done yet is, in the contract mode, would you be using less hours or would there be other efficiencies potentially?
You guys never had an opportunity to look at that?
Right, we have not looked at that.
Because there was a pilot program done about 1998, I believe, in Mendocino County that the LAO did do a summary on. Are you aware of that?
And you're going back, Todd Bland with the LAO, going back into my time, and I wasn't the analyst back then. We'll just have to get back to you, Assembly Member. I'm not familiar with what we said in '98.
Okay.
I can barely remember what happened last week. Finally, we'll go to Mr. Bell, and then I'll wrap up this session with a couple of comments, and we'll go to our last panel.
I had a question on the budget assumptions. We approved maybe the LAO or maybe perhaps our budget staff can answer this. When we had the budget approved, there were certain assumptions that were made regarding how much the cost would be to implement these new regulations and rules and procedures and so forth. And that includes things like the fingerprinting, the visits to people's homes, the paperwork kind of additions, all the things listed in the report. And then there was also an assumption for the cut that we had to do for lowering services enrollment and also fraud detection. How much was that reduction in the budget? What was the amount that was booked, if you want to call it that, in the budget for the reduction to the IHSS program due to all these changes that we're now considering?
So the total reduction, yeah. I think it was about $420 million general fund. That's prior to we have some federal relief under the American Recovery and Reinvestment Act, bringing it down to the mid 300s.
Okay, and part of that was you were going to reduce the budget based on assumptions regarding the fraud. It would be sort of a net. You'd have to spend some money, and then you would save some money, correct? Is that right?
Yeah.
Can you give us an idea of what that was?
Let's see. I think the total funding spent on fraud prevention activities is roughly a little over $20 million general fund, and the savings were booked at $184 million general fund. So you net it all out, it's about $162 million from fraud, anti-fraud.
And then part of the savings was booked due to the functional scores and those kinds of things that are stayed by the court. And what was the savings included in that?
Those were about 103 million general fund, but when you take into account the federal incentive or the federal stimulus money again, it brings it down to about 82 million general fund.
And as far as the fraud detection, the implementation was in terms of the amount of money, the assumption was that it would be started on September 1st, correct? As opposed to, we just heard somebody say that.
I think it varied depending on the activity. The anti-fraud package had a variety of different activities that we've been discussing here today. Some began earlier, and others we're still in the process of implementing.
So we could say, due to the court order and what we're doing in terms of the confusion that's now reigning here, we're already really behind in terms of those savings that we assumed in the budget. Is that a fair assumption at this point, would you say?
I think the difficult thing is actually quantifying the extent to which the anti-fraud activities would actually result in savings of that magnitude, which is essentially about 10% of the program, which is significant savings in in-home supportive services. So to the extent that the activities would have resulted in fraud savings of that amount, which we're still evaluating, each month you delay implementation, you are eroding those savings.
We're already into this budget year, quarter of the way through already, and then we're looking ahead the next few months. By the time the budget is released to us next year, would we be able to have a good record of whether or not we're achieving those savings that were booked in the fiscal year budget?
I think it's a good question for the department on how we're going to be tracking whether or not we're actually getting those savings. But we will be, we at the LAO are doing our own analysis right now to determine what we think will actually happen. But in terms of how they'll actually be tracking that savings, I'm not entirely sure.
Now yeah, go ahead.
I was just saying, we'll know the aggregate dollars. Even that runs a little bit in a lag, but we do keep track of those. What to attribute to is a little tricky.
Okay, we made an assumption in the budget that we were going to save X amount of money due to this, okay? And that's a pretty upfront number. It's what was approved by the legislature, signed by the governor. We assumed this amount of money would be saved. And then we have this situation that changes things, like we're in now, the situation we're in now. So I would assume that those numbers would also change.
Yeah, they will. It's an entitlement program. So the spending will be what the spending will be. And what'll be tricky, of course, is attributing to the specific programs. And to the extent we remained enjoined by the courts, quote, any savings we might see, it'll only be the places where we're not enjoined or the only possibilities where we would get savings.
Well, that was my question. What options do we have other than the options in the budget and approved by the legislature to make savings? Would one option be to
Mr. Bell?
Maybe artificially?
Mr. Bell?
Yeah.
I think we're getting a little ahead of ourselves here, though, in talking about how we might score different savings depending on what we do, because we haven't quite decided what we're going to do yet.
Yeah.
So I appreciate the thought, because we have to keep that in mind, but did you have questions that were related to what's going to happen on Monday, how we're going to implement this?
That's what I'm getting at.
Okay,
I think
good.
the issue is...
I'm just mindful of the clock here.
Well, I think the issue is, for me, the fact that we have a budget, we made some assumptions, we've already gone into the fiscal year, and now we're looking ahead Monday to probably not being able to achieve what we originally thought we would be able to accomplish. So would the savings options include not signing up people for the next month due to the fact we don't have a system to sign up people, and will we save money by doing that? Is that in effect a way of catching up or achieving any savings?
I think because it's an entitlement program, if someone is entitled to the services, they have to be provided those services. So I don't think that counties could not enroll someone for purposes of catching up because they're not getting the fraud savings. But to the extent some of the other issues we were talking about earlier today, where new providers aren't able to enroll in the program, and by default that has a caseload increase or decrease that could potentially occur depending on some of the logistical issues we've discussed today.
And does the county, the letters we got from the county are very concerning me. Does the county have eligibility to apply for reimbursement of unfunded mandates due to the all-county letter or any other procedures that they're required to do? Is that something that counties can file? And would that be an issue that we'd have to be concerned about?
I'm not the expert in mandates at the LAO. I would have to get back to you on that when I check in-house with our mandate.
And I just want to say that I think one option would be to end the furloughs on SSI and the SSI program, because I believe the SSI program is funded entirely with federal funds. And if our workers in the SSI program were able to process people for SSI, we might make more people eligible for that federal program. And I know it's going to be, we're going to have to patch together something to provide services for people in many different ways due to this confusion. I would think that would be a very logical thing to do, and I think that's something to look at.
Thank you, Mr. Bell. And I do have a concern about how furloughs, the state furloughs, actually overall are affecting the implementation of this new legislation, not only statewide, but also on the part of the counties, because I know we're experiencing city and county furloughs locally, and I know that's happening statewide. Can't help but have an impact on this program. So I said that what I wanted to do was to throw out some positive suggestions here. And there's a couple of things I want to suggest. I'm not sure how to implement them. If I were able to, I would just say go do it, but clearly we can't do that without legislation. But I think that's what we're going to look at doing right now, is introducing some cleanup legislation next week. And one of the things that I will be considering is specifically requiring a stakeholder process as far as how this gets implemented. Honestly, I didn't think it was necessary in the original legislation because of the good track record that DSS has had in the past. And it's unfortunate that we're at this point, but I think we'll have to require that. We'll have to look at new dates. One of the things I want to do, because my reading of the legislation is very different from yours with respect to what is a prospective provider, or what the definition of is of someone seeking to become a provider. In my understanding and my reading of that, and as the person whose name is on the bill, the way I intended it to have been read was to be someone who is a completely new provider. You know, there's already about 30% turnover every year by providers as far as the recipients that they provide for. Going from one recipient to another, in my opinion, does not make somebody a new provider or somebody seeking to become a provider or a prospective provider. It's just somebody, it's an existing provider going from one person to another. But the way that I'm understanding your reading of that is that makes them a whole new provider in the
We agree with you.
All right, that's not good. I appreciate you putting that on the record, because from what you had said earlier, I didn't think that was true. And I think that is in itself causing some chaos on the part of the counties, because they think they have to provide all this new process for all these people that are changing from one recipient to another. So there's a lot of clarification that needs to happen. In the meantime, though, I'm extremely concerned about what happens to folks, because we got this computer system that's now going to say benefits denied as far as the providers are concerned on Monday. And as I've said before, these aren't people that can carry the state for an indefinite period of time as far as getting paid. And obviously, the state cannot do this to the recipients because it is an entitlement program. So one of the ways in which we cut back on what we're going to pay through the program is to not provide the payments to the providers. And I don't like that. So what I would like to see happen is for the counties to have some direction from your department that they can continue to use the current system and the current law until we can get a handle on how we're going to implement this in a way that doesn't cut people off from their benefits. And I'll just say for the record, in my opinion, cutting off somebody's paycheck as a provider is an indirect denial of a benefit to a person that is entitled to that benefit. And that may or may not, that may or may not be legal definition that would hold up over time, but that's my opinion. And I'm worried about that happening here. And given the good work that DSS has done with the counties in the past, I want to see that continue happening. So that's what I'm going to suggest going forward. I don't have the authority to order you to do that, obviously, but I would greatly appreciate it if you would give that some consideration and work with the counties between now and Monday to figure out some way we're going to deal with this. And then we're going to go into legislation next week. At this point, I would like to excuse you and thank you very much for coming. And we've got a final panel, which I'm going to have to ask to be very brief because we really have run out of time. I hope the sergeants can accommodate us for another few minutes here at least. I actually have a briefing on water I'm supposed to get to at 3:30, which is another burning issue in the Capitol right now, as we all know. For the next 5 minutes at least, I'd like to call up Deborah Doctor, legislative advocate for Disability Rights California, Jovan Agui from APSME, LaFonza Butler from United Long-Term Care Workers, and Donna Calame from San Francisco IHSS Public Authority. And I apologize, you each have about 30 seconds. So if you would start out, please.
Thank you, Madam Chair and Mr. Chair. I'm going to talk really fast because I've been adding things madly to what I was going to say. I want to make clear that we are hearing things for the first time today that we've not heard before and consumers haven't heard before, such as even the possibility of back payment for providers who are hired and haven't gone through the process. In fact, the letter that consumers got, I think that was sent on October 5th, says exactly the opposite. You hire somebody, they haven't gone through the background check, it's on your dime. So that's news. Some of these things have already started happening. These unannounced home visits have started happening. They include people in uniform going to clients' houses, 3 at a time. We agree with you that people are scared, that the notices and letters, instead of acting as guideposts, have acted as traps. And I'm sure that's not what you want to see and not what DSS wants either. I would love to go into some of the other issues from the underlying legislation. That's not our purpose today. But I just want to tell you that the first time my organization, Disability Rights California, heard about that these letters had gone out to consumers was when a woman from Grass Valley called. She got a letter about the convictions and called the public authority there and said, my husband is my provider. He has a criminal record. I might as well just die before next July 1st. So I hope we can have another conversation, a more substantive one, about the consequences of some of these provisions. Thank you.
Thank you very much. Donna Calame.
Thank you very much for this hearing. I'm going to abandon the remarks that I had outlined, and I've made some notes of comments and questions that were raised along the line, and I hope they might give a little bit new or answered response from my point of view. It's great to hear about a possibility of cleanup legislation, and I would have some possible suggestions to be entertained there. First, there's been no reference, and I just found out this week myself, that there is case law under Welfare and Institutions Code 10,000 and 10,000 or 10,500 that talks about counties and state having good policy with regard to needy people on public assistance. And it's my understanding from a legal services attorney that it's not just good policy, but that there are duties imposed. And so I would just like to encourage everyone to think about some of the questions even today we're raising, whether there can't be more proactive and humanely oriented implementations of laws, and that may in fact be a requirement for this county and state to do that. I would encourage the cleanup legislation to delay implementation and again make clear that the old law could stay in place until effective new implementation to be carried out. With regard to the enrollment form, Senator Lindo, I was very happy to hear about your legal opinion. I've had problems from the time I first saw the enrollment form. It could well be that the DCHS lawyer is correct about the 1400 provision and the federal law, but when I looked at those as a person legally trained, I'm a lapsed lawyer, but those provisions apply to or seem to be in the context of institutional Medi-Cal providers, not on the order of independent providers under an IHSS program. I'm quite sure there's a legal analysis, and if there's not, then I would encourage the state to change its law, narrow the exclusions for who can be an IP provider under IHSS, and make clear that family members with criminal records can serve other family members. Public authorities were created to improve the IHSS program. It's very painful for us who are running those public authorities and staff that's being reduced there, programs being reduced there already, to see the possible dismantling of this program, which we've worked and honored and tried to improve the program, and might, in our success, have actually made it a target. Some public authorities may literally actually end up going out of existence because they just can't keep going forward. So I would, at the risk of seeming self-serving for my compadres and myself, urge you to look at a letter that will be provided to you today with the impact on them. Ask that you, again, support public authorities as a service. You can't ask the counties and public authorities to do more with less. Insist that we be at the table to collaborate, share our experience, and work on solutions. Restore support for public authorities as the voice for consumers and in our role as employers of records for IPs, and allow public authorities to continue to help to improve this crucial program. As far as possible, I don't think there can be any other savings of IHSS. It's a very lean, mean program. Let's look at revenues, vehicle license fee, oil tax severance, internet sales. There was a question about whether it's good policy. A consumer-directed program that's non-bureaucratic, where consumers can hire who they want to have serving them, is what the federal government is looking at. It's the trend that they're moving to. Researchers in California can show that IHSS has reduced the more expensive use of public dollars in nursing facilities. So just wanted to throw those out as far as questions. Thank you very much.
Thank you very much. Mr. Agee, sorry.
Thank you, Madam Chair. I really appreciate this forum, having this discussion. I think it's long overdue. Coincidentally, it's exactly 3 months after the budget was signed and adopted. But to me, I hope this is a lesson learned. We can't have major programmatic changes in this state and do it in haste. This was not an inclusive process like I've seen in the past, which troubled me. And like some of you have voiced today, I've stopped by your offices and warned you of what was to occur. So I hope moving forward that the level of interest on this issue maintains, not just from today, not just from you all, but also from the administration. I think the administration has an obligation at a time like this, in this state of great crisis, whether it be fiscal, it's affecting everyone severely, not just in IHSS, but we need strong leadership. We need leadership from the top down. And what this reminds me of is a bad version of the Wizard of Oz. It reminds me of, since 2003, we've had someone come in who said they can do a better job than our previous governor. We've all walked down the yellow brick road trying to get to the Emerald City to follow that voice we've heard, or that person we've heard about, just to get there and find out that the person behind the curtain is not who we thought he was. So thank you very much for your time. I hope that the cleanup legislation process is inclusive of everyone, so we can add our valuable knowledge and help this process and make things right for the people that depend on this program. Thank you.
Thank you very much. Mr. Harris? Again, the audience, I need quiet, please. Mr. Harris?
Madam Chair, Mr. Chair, Robert Harris for SEIU, and it's 200,000 home care workers. We care about program integrity. We've worked hard to try and add integrity to the program, working on 6 different pieces of legislation on background checks, for instance. But what's happened on this process has been total chaos. The all-county letters or notices that went out to recipients also went to providers. And we had providers calling up and saying, I'm going to have to quit right away. We've had providers going in, filling out the draft provider enrollment form that accompanied the thing and turning it in without knowing even what the disqualifying misdemeanor crimes are, and yet they filled out, I didn't commit one. And they don't know. I mean, it's just total chaos out there, and it puts people at risk and at jeopardy for having lied when they didn't intend to, if the crimes end up being things that they didn't think were serious. I mean, so that part's insane. In terms of what Mr. Leno raised earlier, and I think this is really the case, is the department's so overwhelmed with trying to make these deadlines that they misread the law. And what they're saying about the provider enrollment forms did indeed refer to the provider signed agreement form. And we just got on Monday an all-county letter to implement that with the comments due back Thursday, right? And so by Friday they're going to implement this thing, whether they take the comments seriously or not, and then expect the counties to do something about it on Monday. I mean, so that's insane, but it's also becomes clear that the intent of legislation, I think that you put your name on, Madam Chair, was not that they fill out a new provider enrollment form, but they fill out the provider agreement form, which is a totally different thing. And even though the form is totally flawed and full of errors and contradictions right now, that's something that can be worked with and worked out and made to work if we just slow down and take the time to do it, and do it rationally, sanely, and include the opinions and knowledge and the experience of all the people at this table who have been working on this issue for years.
Thank you very much. Thank you all for coming and testifying so briefly. I apologize the time was so quick. Members, that completes our panelists and question period. I do want to thank everybody for participating. Thank you to the counties for their testimony and their assistance in this. Thank you to the department, because I know this is difficult. It's hard to be on the hot seat. But I think this is really important that we get this right. And I think it's just really clear that you can't make good policy in haste and secrecy, and that's really what this is the outcome of. So I want to announce to everybody, I'm going to have another hearing on this issue, November 5th. And that hearing will hopefully address two things. One, it will address what's happened between now and next week, between the counties and the department and the recipients and the providers. And it will also hopefully be a hearing on the new legislation that I intend to introduce. So the time and the place will be to be announced, but it should be on November 5th. So thanks everybody for your participation today.